What's up, everybody? We are so excited to have you here today. Happy Tuesday. So, I am super excited to have a repeat guest for you. This is Michael Coates, not a doctor, an attorney, who is a longtime viewer and in the last year has became a presenter on the webinar series. And it's really awesome because I love to shake it up and have different people with different perspectives. And he really has such incredible information on what it really takes to make personal injury easy in your practice. Um, I can honestly say that getting to know Michael in the last year has been just incredible. He's been a tremendous resource for all of our viewers. He's been a tremendous resource in this profession. We've been just hung out a couple of months ago at a convention, and I had the most amazing time with him. Got to get to know him so much better. And I can just tell you that Dr. Foxworth and I, we just had the best time and we learned so much. And we love that we're able to introduce speakers like this to you. So if you haven't seen Michael on our webinar series before, you can always go to the archived webinars on our website and you can actually search by his name and see previous presentations that he's actually done. Because again, he has so many nuggets of truth. He really does break it down to make it easy for you to be successful in practice, especially when it comes to having personal injury, because Lord knows some of those other attorneys out there sure do try to make it difficult for you. Luckily, we have one on our side like Michael who doesn't. So, Michael, thank you so much.
Christy, thank you. Before I get going on my part, I want to give kudos to you, Dr. Foxworth, and Chiro Health. It's including it dovetails with personal injury, but it's so important. I think that they're aware of what you do as a product and as a service. And that's fantastic. And Dr. Fox is just one of the most lovable, giving, caring people. And he cares so much about, and you, about the success of everybody. And that's what I like about your approach. And you bring on all these different speakers and different subjects that have nothing to do with what you offer. It's to benefit all the people that you are in touch with. And I think that is so special. And I think it's just reflective of you, him, and all the team over there at Chiro Health. And so I give my kudos and applaud to each of you. And I just hope you continue to do what you do, bringing great content and value to all the members, because in the end, what we all want is to raise chiropractic up to where it should be. And it isn't there. And there isn't a chiropractor that shouldn't be ultra successful, and all the patients need that out there. So thank you, Christy, and with you and all you do. So I'm going to jump into personal injury, and it really is the best kept secret to chiropractic success. And I mean that with all my heart. But first, I know there's a lot of people that are here, and I kind of like to get an understanding of why are you here? And I emphasize you, because this isn't about me. This is about you. So there's three questions I kind of want to just start with. And I know a lot of you just kind of finished lunch, so let's kind of shake it up a little bit. So I want you to raise your hand if any of these questions fall to you, and I hope they all do. So the first is, do you want to grow your patient volume? So raise that hand. If you want to be more profitable as a business owner, I want you to raise that hand. And if you want business to be easier, raise that hand. So if you raised your hand, hopefully all three times, you're in the right place. Let me start off with just a little story with a client of mine from California, Dr. Tran. And this kind of signifies the problem in the area and the risks that have been involved, but also the success. He was getting only 20% of his bill being paid by this particular law firm. Now, that's not uncommon to many of you, but the problem here was Dr. Tran had 175 open patient matters with that single law firm when he came to me. Imagine if he got only 20% on all of those, I call it a practice killer. It would kill his practice. He'd be done. But as we applied proven tactics and started collecting and things, I'll share some of that with you today, he was able to get 80 to 100% of those monies. Think of the difference that made. Just in a 6-month period, he put $200,000 into his pocket. But that wasn't the biggest thing about it. I think in this day and age of COVID that we've all been through, I just had COVID over the holidays myself, is he called me up and said, Mike, I want to tell you that you saved my practice. And it wasn't because of of just the fact you were doing well, that this happened well with the attorney. The reason why you saved my practice is because my staff had COVID. I had to shut down for a lot of weeks. I couldn't see patients. I couldn't bring in monies. But every time I went to the post office and got my mail, I got these PI checks. And it had me paying my bills, saving my practice. I can't thank you enough. And that really hit home because I hadn't had someone really call and tell me that. I think COVID just brought a lot of new things to light. So I want you to know that this really does work. It really does a way to elevate your practice and to protect your practice in so many ways. So let me tell a bit about my story. So I am the founder, and as my staff likes to call it, the chief disruptor of Personal Injury Made Easy. My path started as an attorney where I was representing in personal injury defense and medical malpractice defense. So defending doctors like you way back. And that was my first 3 years. I loved that, competitive. Then I went to representing financial institutions. I got to the commercial side and I was really good. And I moved up to being a partner in a large 670-man national law firm. Life was great. But then after 10 years of being this attorney, being paid by insurers and business people that didn't give a damn about anybody, it really got to me and I got burnt out. And I searched for a path. As we all have our own personal tragedies. I lost a business, a marriage. I lost my dad. I lost a son. I've lost a lot. And I felt alone and I didn't know where to go. And one day, this chiropractic buddy of mine came up to me. I just met him we were at a local restaurant. And he said, Mike, I got these 5 attorneys trying to screw me on my bills, and could you help me on this? So I'm saying, what, this medical lien stuff? Yeah, so I'm looking, okay, let me do it. So I took him on. I got him 100% paid on all 5 matters. His jaw was dropping, saying, oh my God, Mike, that's not what usually happens. And I went, really? Well, here's something else I said to him that was really interesting. I said, on those matters, 4 attorneys called me. And they all said the same thing, which is really odd. And they all said this, just change the number of years in the space. I've been doing this for 25 years and I've never had someone champion a chiropractor. And I thought, can that be true? Was there nobody standing up for you guys? And what I found was, when I researched it further, it was true. But there was worse. I got horrified. I learned, and I didn't know this because being on the defense side way long ago, I never was privy to this. I couldn't believe the lies that I saw that attorneys were telling, the hiding of settlements, the taking of med pay, and in other states it would be PIP, the lowballing, the lying about law. And then what was even worse, I was witness to the abuse of staff and medical providers, verbal abuse, written abuse by a lot of the law firms. Now, there's a lot of great attorneys out there. So trust me, man, there are some great people that really care, but there are too many that don't. And it's all about with them. What's in it for me by them? So I've made it a personal mission. I found someone I really could get behind. You, the medical provider, the healers and the givers, to champion you guys. And over the last 10 years, I have championed and trained and educated hundreds of providers in thousands of matters to get millions of dollars. But I wanted to do this on a much bigger scale because that was just California. I wanted this national. I want to change a broken industry. I want to make it so it's treating you, the provider, right. And so my mission has been on a national level to educate, coach, train, and mentor. And so that's what we're doing part of today. And I love doing this. I can't tell you how much I love just educating and helping. So let's talk about PI and let's get into it. It's like, beware of the sharks. And we all know when, the traditional view of shark, it is an attorney, but it's more than just that. It's the insurance companies too. And you know that from even the non-PI, right? All these tricks, traps, and ploys that are done, it's because all these sharks are looking for the easy prey. And when they fight them, they gobble them up, and that blue water turns red with blood. But here's the truth. Here's what I want to change in your eyes is that it's safe to go back in the water because it's a matter of perspective. That big fin on the water, oftentimes when you get underneath the water, it's a whole different thing and of knowledge. You don't know what you don't know. Today, we're going to go through some things. I almost assure that you're going to learn something a little different than maybe you knew something, but not quite that in that spin. It's going to help you in your practice. And when you do that, not only is that confidence there, but the results are going to show. And I want that for you. So let's change the perspective. But before I get into the meat, I think it's really important to know not just what I do, but why that I do it. Because the why really is more important for me than the what. First is, I believe you, especially chiropractors and the great people at like ChiroHealth, you guys are the heroes. And in PI, the reason why you're the heroes to me, first of all, you bring patients back to health that are in pain. And you do it without needles, without surgeries, without drugs. This country needs not less of that. It needs a heck of a lot more than that. And so the second aspect is not only do you do that, but and because of that, I believe you deserve better pay, better communications, better respect. Because remember, you also utilize your bills are the support for the patient's case. The reason why they get the pain and suffering and the damages is your bill and your treatment and your documentation. And the attorney uses that offensively. And the last reason why I think you deserve better is because on top of all of that, you wait to be paid. And so I tell you, I think you deserve better. I think you deserve better pay, better communications, and really better respect. And that's not just from the attorneys. I believe it's from the adjusters. And I believe it's from the MDs, the more dollar doctors. Yeah, those guys. And I do believe, as I said, PI is a broken industry, but everybody, you guys, it can be fixed. And by the way, when I say guys, it's guys and gals, that this can be fixed. It just takes all of us to be doing it right, to standing for what's right and standing for what needs to be done and forcing that within the industry. In the end, it's going to help everybody. And what you're going to find, and what I believe, is that PI should be the most lucrative practice segment that you have. I know it is. You just got to compare it, if anything, to cash and insurance. And insurance and all those things are getting worse, not better. So nothing pays better than PI when you do it right and you get the value of your worth. Like, is there any greater value in business than this? I should say this, what's signatory to that is when someone does work, issues a bill and gets paid their bill. That means you are paid the value of what you believed is your worth. And when you don't get paid that, what's that telling you? You're not worth that. In fact, when you do the reductions when really you don't need to at times, you're devaluing yourself. And I don't want you to do that anymore. And I want you to know the law is on your side. The attorneys don't want you to know that, but it's the truth. Lady Justice on the left is about justice. And what you see, because justice is blind, because it should be fair to all. But the problem is the attorneys want you to have the blindfold on so that you're not realizing that the law is on your side. So today we're going to cover some of those secrets to get you started. Obviously, look, you went to chiropractic school. You started the path then to master your profession. You learn technique through school. You practice. You really start to master it being out there in the real world, having a practice, the real patients doing this every day. So mastery takes time, and it takes being educated, learning how to do things the right way, and then just being committed and applying it over time, like your practice. Your treatment became easier, and certainly then later easy for you've really been doing this. And the same thing can happen in personal injury. So are you ready for that next step? This is a simple formula, but it is magic. This is what I put together through my 10 years of dealing in the gutter with these attorneys and educating, training clients on how to make this right. It's where you can get a PI power practice, and it's 3 segments. It's your processes times your payments times your profits. And that your processes are your intake, your lien, your PI healthcare management that's unique to PI. Your payments are getting yourself paid. How long, how fast, how much. And profits is about, remember, it's not about how much revenues you take in. It's how much you keep in your pocket at the end of the day and scaling yourself up for growth, because what you want is that successful practice that is worth something and worth a lot. So before we get started, and I like to do this, especially when I'm doing workshops, is I want you to evaluate your score. In fact, every time you are ever going to be with me, you're going to be doing this again, because I really want you always to have that updated score with your practice. And it's really simple. So I want you to get back to the formula. So what we're going to do is take a less than a minute, and we're going to do a 1 to 10 self-rating by each of you on each of those 3 segments. So the first thing I want you to rate yourself on a scale of 1 to 10, 10 being best, for A, on processes. So rate yourself on how good your medical lien is, your intake, your healthcare management of patients unique to PI. Where would you rate yourself? Okay, great. Now let's move to payments. For getting paid in PI, how would you rate yourself on a scale of 1 to 10? And if you're getting 100% of your bills paid 100% of the time, you, my friend, are a 10. I suspect it isn't the case, but only you can rate yourself. So give yourself a rating with B, where you are with that. Great. Now let's move to the last one, profits. So how profitable you are as a practice. And that means, first of all, you should know where is your break even with patients you see. Have you met with your CPA to figure that out? Do you track the law firms and the results you get to know how profitable you are? Or have you set your practice up to scale, to grow? So give yourself a 1 to 10 self-rating there. Got it? Okay. Now I want you to multiply your score for A, processes, times your score for B on payments, times your score for C on profits. What did you get? How did you score? So the possible score you could have is 1,000. So only you know what you just got. Do you see that you have room to improve? I suspect some of you, it feels like it's a mile, like that rocket ship going up, but I can help get you there. Even those who have been practicing for a while, there's always room to improve. And even the veterans, I expect that why you're a veteran is because you've also realized learning never stops. Getting better never stops. Mastery never stops. So even there's improvement even there. So I want to show you how. So let's get to it and let's hit it. We're going to start with the first segment of that formula, processes. And this is about efficient systems, great documentation, proper personal injury patient healthcare management unique to PI. We can only hit so much in the short time we have. So I'm going to cover 2 things for you today. First one is on documentation, and it's around SOAP notes. Let me start that with a little story. So I had a client that wanted me to help them. So I asked them to send me over a typical SOAP note they had for a patient, redacting out the patient's name so I could read the SOAP note, so I could see what they did and why they did it and how they were laying that out. Well, what I got was a bunch of medical mumbo jumbo. Remember, I was a medical malpractice attorney early on. And let me tell you, I couldn't interpret what the heck this guy did. And so I went back to him and saying, and the way to get the point across, if you took these notes to your receptionist, would your receptionist know what you did, could describe it to the patient, and why you did it? And he said, well, no, but she doesn't need to. I just need to. And bingo. That was the problem. The doctor wasn't realizing the audience is unique in personal injury. This is the one segment of your practice. You actually have a little microscope on you. You're being watched by others. And the others you're being watched by are not doctors. You've got attorneys, adjusters, judges, juries, patients. None of them are doctors. So you need to have your notes in clear, simple, regular, common speak. So take out the medical mumbo jumbo. And when you do, realize you're helping your patient. You're helping the attorney because you're making it clear for the insurance adjuster, and that's going to help them get better results and faster results. And the real key is storytelling. You know, the great trial attorneys are the great storytellers. Litigators are not trial attorneys. The great trial attorneys, you can hand them a file and basically they can walk in front of strangers and convince that group, at least half of them, plus one, on what they're trying to advocate. That's a scary thing. It's like public speaking. When you're in front of a bunch of people, Zoom today, making it easier, right? I'm not seeing anybody. But it's scary when you're in front of a bunch of people. And a lot of people aren't good they're not good storytellers. They're not even really good attorneys out there. They're unfortunate, just going to be honest, there are a bunch of them that aren't very good. And you see it reflected in a lot of the results. And the insurance companies know that. They take advantage of those that aren't good trial attorneys, that aren't good attorneys, that wait too long to file matters, that are afraid of trial, that just don't want to invest in cases. So how can you do storytelling soap notes? The focus here, and for PI, is the life before the personal injury incident to the life after. And that's utilizing the activities of daily living. So that's the ADLs. And I'm sure you've heard that before. That should not be nothing new, but your focus and use of it, I think, has not been appropriate. This is the quality of life changes. Home with family, work, social, when you're out there having fun. It's not just physical. You're getting an emotional and mental help. I mean, just think of PTSD that comes from getting in a really nasty accident, or all the concussion issues coming and the prevalence now of TBI, whether mild or severe. And then it's the hobbies and habits that now can't be done, less or not at all. Your appetite, the sleeping, the energy levels, how this is quantified in personal injury and what you should be aware of. It's what the goal of personal injury is. Why do a lot of insurance defense attorneys leave insurance defense and become plaintiff attorneys? Because they don't want to get paid that hourly wage. What they want is when you've got really good pain and suffering damages and you get juries to award a bunch of money. So the attorney fees are huge and you get way overpaid. And that's all based upon that pain and suffering damages. And you are, by showing that activities of daily life effect, you are showing the pain and suffering to your patient who's seeing you all the time. Remember, that patient's seeing you far more than the attorney. So the attorney is relying upon you with that documentation. Now, it might be a little easy for me to say on the documentation on that is realize to do that right in the documentation. Let me go back a slide if I can. Oh, I didn't there, and my apologies. Christy, how best so I can go back a slide. Let's see here. Back one. There we go. Okay, sorry about that. I want to just realize that in that story, I want to do it where you do this in the ADLs around telling the story of your patient. And here's a method. Ask your patient, what was the most important thing that meant the most to you that you were doing before the accident, that after the accident, you can't do anymore? That is just rips you at the gut. What is that? So one of my clients commented that their patient had referenced every day when he got home, he would play baseball with his daughter in the backyard on the grass. And they played for an hour, 2 hours. He would teach her how to, throw the ball, hit the ball. They'd work on it. He'd field the ball back and forth. And that gave him so much joy. Well, after the accident, you know what he could only do at first? Put a chair on the grass and sit on the chair. Couldn't help her at all. It was tearing him up. After a few weeks with the chiropractic treatment, he actually was able to then stand on the grass, throw some underhand pitches, and a little bit, and then he had to sit back down, but he could do a little bit. After maybe about a month and a half, he was able to actually throw it more, interact a little bit more with the daughter, and he was just feeling better with that. Oh my God, that made him feel so much happier. But it was still not the same. After about 2.5, 3 months, he was back being able to play with his daughter, throwing, hitting, catching, fielding, just like before. What did that do? You take away all the medical mumbo jumbo, and what you're describing is something an adjuster, an attorney, a judge, a jury, and your patient can all understand. And that is what hits home on pain and suffering. And that's going to have the good attorneys and the great ones want you over your peers because you do that right. So let's get to the next area of process, and that's the right medical lien agreement. This is your contractual foundation. I suspect now some of you might own your building, but I believe that most of you probably lease your office. When you did that lease, I bet you got this long 20-page contractual agreement, a lot of little writing on your duties, obligations, yourself, the landlord, and then what happens when things go south. And that's a lot of pages. And of course, you sign that because you're in business. It's part of being a business person. Well, in PI, that contractual agreement is the medical lien agreement. It's not given a high enough deference and focus in PI by providers because it is the one document when you have the right one that's protecting you the right way that you never need that with the great attorneys, the good ones, they're going to take care of you anyway. But it's for the ones that surprise you, the ones that have another intent, or where things go south, or where suddenly that patient that you thought loved you sees some money, greed takes over. This is where you really can take an advantage. And it's about bulletproofing that lien agreement. And here's a great way I like to analogize on bulletproof. Yeah, I'm a fantasy movies and science fiction fan, and The Matrix I love. And think of the end of the first one where Keanu Reeves, Neo, is being shot at by all the agents, and you've got these hundreds and hundreds of bullets coming at him. Puts his hand out, stops them all. The bullets fall to the floor. When you have the right lien agreement, you're like Neo. As all those bullets being shot at you by these attorneys and people trying to poke holes in your bill and what you should be paid, a lot of them are just going to fall to the floor. You get the leverage because of that document. That's how important this is. So let's talk about what should be in the right lien agreement. And you're going to, if you know yours, you'll already know. And if not, look at it right after this. First is the patient's obligation. And that is simple statement. The patient owes the bill regardless of the outcome of the case. Let me repeat that. The patient owes the full bill regardless of the outcome of the case. And that is the truth. Even the common fund jurisdictions, where you're limited on amount from settlement funds, the patient still owes the balance on almost all of those. That's why they call that full and final. And this way you're letting the patient realize that, and the attorney, of course, know that. Then interest. And having an interest provision in there, that's your one protection against time. And time matters. When you got to wait, let's say it's a lazy attorney, it takes years to even file and then years to get a case resolved, you got all this extra follow-up. How do you get that money back on top of it? Well, interest can help you. That doesn't mean you have to demand that they do it. That's your choice to give it up, but have the protection there just in case. And then the attorney fiduciary duty. When they sign that lien, that means they have a fiduciary duty to you on top of their own client to protect your financial interest in those settlement funds. Now, some states are a little clearer than others, but the one way to make it really clear is to state in the lien, attorney has a fiduciary duty to provider. Boom. That now means you've got a much better leverage on them if down the road things go south. Then, of course, we cover the MedPay PIP turnover mandate, which has really been happening more and more. I probably get more calls and contacts on MedPay and PIP than anything else. We're going to talk about that a little bit more. But if you have a turnover mandate when MedPay PIP is issued on your bill, that contractually is going to help you. And then, of course, when a matter settles, you don't mind considering a lien reduction, but you need to know what's happening. What's everybody else getting to decide whether what you're getting is fair and you should. And that comes from a full settlement accounting mandate, again, in the lien agreement, saying that will be provided. A few other things you want to hit. You want to say in there that lien reductions are never to be assumed. Assumptions are the you know what. Put your own definition. But man, does that happen in PI. How many of you, raise your hand where you're sitting, have had a letter coming in the mail with a check, and that letter says, this, and you can hear the little violin playing in the background with the sad music. We weren't able to recover enough in the case, and we can only pay you $1,000 on your $4,000 bill, and this will confirm our agreement. And they never even talked to you. They just sent you a check. They assumed you'd take that. They want you to assume it. And they want you to deposit that check, which says full and final. So that's it. That's why you should always say lien reductions are never assumed. We address them on a case-by-case basis. So then, of course, if things do go south and, you've got that attorney fee provision. That's the attorney fees are paid to the prevailing party in a litigation to enforce this agreement, right? That's standard language in most any contract. So no attorney should ever have a problem with that provision being in it. What you want to make sure you do, and I bet those of you that have it in, have it below the patient's signature line. When it's below, most likely it doesn't apply. Get it on top, put it in both places. And the reason isn't for you to sue the patient. The reason is leverage. Because if the attorney's messing up on your bill with you, that may increase the patient's personal exposure because of the attorney fee provision, which means the attorney may be worried about malpractice by his own client against them. So it's a great leverage item. And of course, if you're going to have some sort of a battle with an attorney on your bill, you want it in your county, in your state. Some of you sit on the border of a state, or you're maybe in a small state and there's a lot of different states you access patients from. You're not looking to travel to other places or other law apply. So your contract, like your lease for your office, states what county, state for the law and litigation applies. And you want that in yours. And we had something really new that just applied in California, and nationally, and that's the No Surprises Act. And that's really important to all of you. In all medical specialties, now there is transparency is really taken front and center stage. And that's being upfront about what your fees, your charges, and over whatever you're estimating for the path of a patient, giving it to them upfront so they have a choice. Now, of course, in PI, they're not going to submit it to insurance. They want it waived. So you should have a waiver in there, because if you don't, these attorneys, those sharks are going to use it against you later on. You just know it. And then you want the current attorney, which attorneys change, to sign that. Because when they change, it's the one who signed the lien that is generally bound. So when they change attorneys or bring in co-counsel, get that person to do it and realize your lien is your ultimate protection. It's Neo holding the hand up and the bullet's dropping. It's also a shark filter. So when they go to make changes on your lien, striking things out, fiduciary duty, important things like that, you are getting red flagged that this attorney loves red water and wants to gobble up somebody, and probably you. So you've got choices at that point that you can make. So it's a great filter mechanism. Although most law firms, they don't even read them. They just get them and sign them. And then when they sign the great liens, you're protected. And access the one at PI Made Easy. Compare it to yours. It's by far the best out there, and it's copyrighted. So, but I'd love for all of our members and people to use it. It's important.
Michael, I have a quick question. What happens when an attorney won't sign it?
Great question. When an attorney won't sign your lien, remember that you have the ability to then, and by the way, when you're using this lien, it says if they don't sign it, it's a lien breach. Again, what's good when having detailed liens that talk about circumstances. But what you can do is declare a breach of the lien. So declare, if you're not signing it, that means the person is receiving the funds and is supposed to protect my interest, has basically by not signing said they're not going to. And forget the letters of protection. They mean nothing in most states. You want the lien signed. So when they don't, you say, well, I'm then not going to wait to the end of the case to be paid. So I'm declaring a default, and the patient's going to need to pay me now. And the attorney still is not doing that. Send a letter to the patient, call the patient, let your patient know your attorney is not signing it, and therefore I'm sorry, but I have to have you pay me now, and I didn't want to, but your attorney's not signing my lien to protect my interest. Can you see how the patient's going to make that phone call that attorney, and make them sign it very quickly? So that's how I would address that. Okay, let's get over now to that was processes. Let's get to B, the second area, which is time to get paid. So this is where you've got to negotiate with the law firms. And that's where you're leveraging facts and the law within strategic negotiations. Okay. And again, it's getting paid. And with attorneys, they're hiding something. Look at that guy hiding under the table. And it's so true. I know that most of you have been told when you want to ask, what did it settle for? Can't tell you. What are your attorney's fees? I can't tell you. It's privileged. How much are you paying each of the providers? Oh, I can't. We signed a release agreement. It says that it's confidential. That's a bunch of hogwash. Don't let them get away with it. It's mostly about settlements and payouts, but they do it on a lot of other things. We're just going to focus on that area. What I want you to get is what they send to their own client, your patient, when a case is going to settle. Before they finalize a settlement, they send to the patient what's called an intended settlement disbursement listing. Okay? And that is to lay out for the patient how much it's settling for, how much are the attorney's costs, the attorney's fees, the liens, the gross, and the amount paid, and net to client. That's all they're focused on. How much are they getting? Now, those letters conveniently don't state we haven't talked with you yet generally about the liens or that they still owe the full obligation. But that document really lays that stuff out, and that's what you want to see. So you want to ask the same information, especially if they give it to you. If you get it from your patient, that document, that's like the smoking gun when the attorney tries to tell you other things. But you want to get the case settlement amount from all sources. You want to know the attorney's fees. Are they taking a third, 40%, 45%, and asking you to accept 15% of your bill? How much of a hypocrite do you find in this area? You finished your work at the beginning before they really started theirs. But you want to know that and see that. But if they're contributing like below 33%, okay, or they sent you the patient, okay, there's some things I might do to help. Look at the attorney costs. Ask them for a breakdown. Oh my goodness, the things you'll find if you get a breakdown of costs. You'll find phantom fees like admin fees or investigator fees or just internal things they put on every PI case. You'll find Uber charges for the patient. Sometimes I found loans by parents to patients hidden in costs. And none of those should be taking a priority of any of your bills. And then you want to see, the liens between the other providers because that's where you're getting into profit margin for you as a chiropractor is a lot smaller than, say, the MRI company as an example. So when they treat you the same, it's unfair to you. And you can bring that back to the attorney. That's not right. And you'll see it there and you can do that and go back to them. And then you always want to ask for what are other potential sources of recovery because they hide it. If you ever see whatever is your minimum insurance policy amount that they say that's what it's settled for, but I think you should ask this anyway all the time. Are there any other potential sources of recovery? So in California, motor vehicle collision, $15,000 is the minimum. But a lot of the patients have at least $30,000 for coverage. That means there's another $15,000 available. But a lot of the attorneys don't tell you they're going after that UIM and getting more. They want you to believe that's all there is. So you ask them in writing and make them tell you, and then they're going to reveal that. A lot less likely for them to lie to you in writing than when they do it orally. And utilize the state ethics rules. This is your real power. Most every state has adopted the ABA's Rule 1.15. And this is protecting third parties who have an interest in the settlement, and that's you medical providers. And there's a specific provision if you do have a 1.15, B4, for example, that says that the attorney is required to promptly provide a full written accounting. Well, full written accounting. That means tell me all that's happening. So it's not just you deserve to, and since you're not obligated to reduce, I want this information, but the attorney is bound to give that to you. So don't let them not tell you that and use that against them. And that's where it gets into using strategic negotiations, right? It's that bulletproof lien, which hopefully, if not before, at least you'll get it going forward, the state bar ethics rules, and really, I believe it's standing for what's right. When you stand for what's right, don't you feel good? You feel energized. You can sleep better at night. And isn't it right for you to get paid what you're worth? Especially when you see you're not being treated fairly, that things are being hid. So I want you to utilize those strategic negotiations and stand up for yourself. Here's another area I want to hit. And this is an area I know so many of you are so frustrated. You could rip your hair out and certainly you want to go pound the wall. And that's on MedPay and PIP, personal injury protection. It's about getting yours, right? The insurance company sends it to the attorney, even when you sent them an assignment of benefits. Keeping yours, issued on an EOB, issued by the insurer on your bill, but they hold it and they say till the end of the case because it's reimbursable. Or worse, at the end, they take attorney's fees out of it. And they had nothing to do with the MedPay or PIP payout. And by the way, when they do that, I consider that stealing from your patient, their own client. I don't care if it's in their attorney agreement with the patient because the patient has no idea what they're doing when they sign that. Because when the attorney takes attorney's fees out, who's got to make up that difference? The patient. But that benefit of their policy was to pay you all of it and cover it, not the attorney. So how do you change the frustration to a smile and get it turned over to you? First is, if you've got the right lien, it already addressed that for you. Okay, even in the lien agreement I've got, it'll have a rescission of MedPay, the latest one coming out in February. And then educate the attorney. Talk to them about this. Go over why MedPay exists. And when they hold on to it to the end of the case, even reimbursable MedPay, that's stupidity. It's like making a loan. If I make you a loan to you and a year from now, that money's still sitting on the table, of course I want it all back. But if they paid it out to you, the provider, and it's not sitting in their trust account or with the patient, most every MedPay or PIP provider is going to waive the right of reimbursement completely. Or they're going to ask for just pennies on the dollar. Of course, I want you to also make written demand on the attorney for that MedPay and PIP turnover. And if they're still not doing it, notify your patient, like we talked about before when they didn't sign the lien. Let your patient know what's going on. This is for their benefit. You're going to have to declare a breach of the lien otherwise and have the patient pay out of their pocket now. They don't want to do that. So get the patient working for you. And a lot of this is really about, like I say, it's about transparency. It's going to see on the other side of that mirror. So you're seeing what really is on the other side and they're not putting up a wall. It's a see-through mirror. It's a window. So in here, when using your strategic negotiations by mandating transparency by everybody, it becomes a fair system. It becomes right. It starts with the contract, that lien, the ethics rules that govern the attorney. There's ethics rules that govern you. And now you've got the No Surprises Act to even more be involved on fees and billing and transparency. And by the way, I'm so happy. And I think the lien is, boom, you are so much better protected. But I'm so happy with that No Surprises Act. I like that. We have such a need for transparency. Yeah, it started by emergency rooms and hospitals that, an out-of-network doctor swoops in. Suddenly you find yourself with a $10,000, $30,000, six-figure bill. Wow, what a surprise. But you're going to find attorneys using that for the wrong reasons in your area too, and with you, the chiropractor. And you've got to protect yourself against that. But it all starts with that right lien. So let's review a little bit. We covered two segments. We covered processes and we covered payments for a PI power practice. And we got to hit the last one. And that's profits. Because this is about how profitable you are as a practice. Remember, you're not only a great healer, but I want you as a great business owner. And Dr. Foxworth will talks about this. And I love when he talks about this because it's so true. We want you to do business better. So this is part of that way. And here in PI, this is 100% of the truth. It's a little counterintuitive and you're going to think a little shocked, but it's true. The good attorneys want you paid in full. They want to pay you every dollar of your bill practically every time. Why is that? It's because they want your bill to mean what it says. Why is that important? Because the good attorneys who aren't afraid of the insurers, they aren't afraid of going to trial, they seek to maximize the recovery for their clients. To do that, that means they want solid bills that mean what they are. Because if you always get reduced and accept reductions routinely like that, and big ones, you're setting yourself up for the fact that any deposition, any cross-examination by an attorney worth of any means, that attorney is going to rake you over the coals and reveal your bill is false. It's puffery. It's imaginary because you never get paid that amount. And the good ones want you to get paid in full. So stand up for yourself, your value when you bill reasonably. So let's put aside the providers that don't do it right, that they inflate their bills too much, that they don't do it. For you that do it right, stand for your value. You are and your staff what you're worth. And the attorneys will love you for it. You'll get more of the good ones. And if you don't, who do you think's all in that water the shark's circling in? It's all those that don't do it right, because that's the easy prey that they're going to be chomping on and make the waters red. So which medical provider do you think the good attorney wants? The one that does it right. So that includes doing it right in your processes and doing it right in how you're getting paid. So let's hit it a little bit about profit and loss. Yes, I'm talking about a little bit like a business owner. What do you do as any business people do? You track things. You can't measure what you don't track. It's a really important rule of thumb. So here I want you to track and measure law firm results, and I want you to track and measure your net profits. So we'll talk a little bit about each of those. So for tracking with the law firms, it's like radar, right? You're out there buzzing, trying to find what's in the water. You ever watch one of those movies where they check and then they tell the radar guy, okay, tell me what kind of ship is that? What make and model, what make is that? Is it Russian? What is it? Well, that's what you got to do. You got to identify with your radar. What is there? What's the truth? What's false? So here was what I want you to track. Track the law firm payment history by law firm, the amount, and the percentage. Think of how you can use that. If you historically have shown, and suddenly your eyes are going to go, boom, I didn't realize that I was sacrificing this much for this firm. You can get that result, cut and paste it, give it to the law firm and say, hey, it's time for me to be treated better now going forward. I've sacrificed too much. I don't get bonuses on cases like you do. I only get my bill value. So I can't do those same reductions we were doing before. I got to get paid the full amount going forward for quite a while now. See how that can be used to your advantage strategically? All right. You also want to track how long it takes them to file lawsuits and settle. There are a lot of lazy people. There are a lot that push aside the small matters for the bigger ones. Or there's some that are just not very good. Or they're just too busy. You want to know who those are, because you want to know when you're giving a patient to a law firm who's going to resolve it faster and for more, right? That's better for your cash flow. So then also, how long does it take for you to get the check when you've agreed? Some of these guys, you come to an agreement and you find after months you still haven't been paid, and they've had the money sitting in the trust account. You want to know who pays you faster. Cash flow matters. So the firms that are better or more efficient, that's the ones you want to really do more in that relationship. And so compare firm by firm. When you do that, you can really see a lot of metrics. What's usual by geographic region, whatever, and look at your overall PI performance and compare that to your cash and your insurance, like what a good business owner does. Know your profits, know where you're winning, where you're losing, where you should put more of your time and your effort. It's going to tell you a lot and help you. Because remember what I said, it's not about how much money you make, it's how much you keep in your pocket at the end of the day. Profits matter. And profits that fuel and its growth that you can scale, because there's nothing better than when you're doing PI right and you scale that up, because all those personal and business dreams become reality because of personal injury. So let me do a little bit of a summary then. So we talked about processes times payments times profits equals a power practice. And this was a start. So we covered use storytelling documentation, bulletproof that lien agreement, get the intended settlement disbursement listing information, mandate that transparency, search your rights and stand up for you and the patient when it's with MedPay and PIP. And you're going to help those attorneys that are really actually committing problems with themselves and they need to do it better. It's your role to teach them in this area. Track the law firm profits and loss results and focus on net and scale up your PI. Be a great healer, but I want you to be also a great business owner. You've got staff that is relying upon you. You have family that is relying upon you. You have patients that want you there. And you've got yourself and why you're doing this. Why do you go in every day? What's your why? And is this bringing your why about? And if not, you've got to do things different. You've got to disrupt yourself and transform your practice, and personal injury is the way. Let me give you an extra bonus on the growth side. And it's about the patient follow-up advantage of PI. And again, this is one of those counterintuitive things again. PI takes time to get paid, right? And you think that's a negative. I'm going to tell you it's an amazing advantage. Most of your patients that you see that are not PI, they come in, you treat them, they go. You hope they call you when they got a problem. But it's the last time you're really communicating with them other than the occasional email maybe, if you have their email. But in PI, you have an aging account receivable that requires as a business owner to follow up by staff. So what if every 3 months, your staff is picking up the phone and calling that patient and asking 3 things. The first is, how are you feeling? Doesn't that make them feel good about your office, that you care? You're top of mind when they're out and about. They're thinking about you to tell others who say, oh, I'm in pain or whatever, or maybe they've got something in their own family. The second thing you ask is, well, you still live in the same place? You get the contact information. People move. They go. The patient owes the bill regardless of the outcome of the case. That means know where the patient is and get their email. Because when you have the email, it's the least cost for marketing for you on all the things that you do. So grab the emails and market to them and educate them of all the wonderful things that chiropractic does, from wellness to active care to preventive medicine to gut to the head to all the things that chiropractic has done such a great job of. And the third thing you ask, how's your case going? You'd be surprised what a patient will reveal that doesn't jive with what the attorney's telling you. Might be, I got paid months ago. What? Whatever it is, the red flags may go up. You got to put a phone call into the attorney. It's something to keep on track of, make sure, because again, cash flow is king. You want to get your money at the soonest point you can. And that comes from knowledge. Track not only the law firms, track your patient cases, and that's going to help to track it. Oh, by the way, for trackers in the PI Made Easy side, we've got these, not only a great attorney audit tracker, we've got this amazing personal injury case tracker on Excel spreadsheets. Now, maybe it's too much for you that are doing just a small percentage of PI, but you can see all the things you could be getting and should be getting and modify that for your practice. So realize, and I hope in our time, that it is about perspective. I hope that through our time here, your perspective has transformed. I hope how you went and scored yourself, that you see leaving today, you might change a few of those numbers because of what you learned today. Now you have a higher score already on that PI Power Practice formula. And I hope to continue to work on that with you for a long time to keep raising that up. It's not about perfection. Progress is perfection. And I want you progressing. Because chiropractors, you are the PI heroes. I believe that down in the deep recesses of my soul. I love what chiropractors do. You guys are the rock of the local community. I mean, my buddies, they're the ones that sponsor the local soccer team, the baseball team. They're the doctor for the local football team. You are the face of medicine in the local communities. And I want to see that respect coming back. And I intend to help you get there. So never be afraid to ask for help. Not from your peers, great people like ChiroHealth and Dr. Foxworth and Christy. Come to me at any time. Come to the PI Made Easy site. Go to other experts out there and all the great seminars and talks that ChiroHealth does. This is all there to help you, and never be afraid to ask for help. So with that, I do want to invite each of you to a 3-day Zoom event that I'm doing March 25th, 26th, 27th. This is the next one. Is Profiting and Personal Injury Live that I'll be doing over 3 days, really diving into some of this stuff and helping you. So when you come out of that, your staff who attends will be on fire. So I hope send me an email at success@pimadeeasy.com or me directly at mcoates at mcoates at pimadeeasy.com, and we'll get you on the list. It's a little pre-registration right now, but I'd love to see you there, and I'd love to help you more because I love to coach, train, and mentor. So that, Christy, speaking of coaching and training, what questions do we have, my dear?
So I have a question. How is an attorney in breach of something they are not signing?
Well, it's not that they are in breach. It's that the document is in breach, the contract, because the patient signed. There's a contract. I'm sure you had the patient sign. So there is a contract. It's the patient's the one that's going to have to suffer from the attorney's actions. And that's why the key player in PI for everybody is the patient. They're the ones that against a med pay or PIP insurer can bring a bad faith claim. It's why when they tell that med pay or PIP insurer, pay my doctor in full and now, they're going to listen, said, oh, or else I'm going to bring a bad faith claim. They're the ones telling their attorney, hey, sign this now because I'm not paying this money or I'm suing my own attorney. They have the leverage. They have the leverage with you for medical malpractice. We all listen to the patient in personal injury. They're the key. So you've got the key. Utilize it.
Should we sign a letter of protection from an attorney? If yes, when do we send them our lien?
Personally, I think letters of protection, okay, they're promising to pay you, but that's like some handshake with not a lot of meat behind it. Some states are a little bit better with others, but I would have all of you always have them sign a lien. Now, any lien is better than no lien. The lien that I'm referring to is the ultimate protection. You're a business owner, you're going to decide on what risk you will take yourself. But I certainly would not be relying on a letter of protection. You have the right, it's like Fast Times at Ridgemont High. Remember, no shirt, no shoes, no dice. Well, you get to decide on a patient. Are you going to have them as a patient, keep them as a patient, or kick them out of the office if you have to? The patient has a choice. You go to your patient and say, hey, I need your attorney to sign the lien, or I need you to get a new attorney, or I need you to get a new provider. You're a business owner. Don't forget to keep your business hat on. You're not just as a healer and a giver. That doesn't mean give of your time for free or give away the shop. You've got to reconcile those two hats.
What language should we use with an attorney that tells us the breakdown is confidential information?
Great question. It's something we talked about earlier. First of all, it's not confidential. That's the first thing. And you can assert probably your state rule 1.15B4 in particular, or find whatever that law is for your state, but it's not confidential. Think about it from common sense. It requires the resolution of liens for any settlement to conclude. Therefore, even defense attorneys, they have no problem with information going to lien holders because they know that that's what it takes to resolve the case. It's not confidential. You're being told a lot of bull. It's just not true. But then you say on a second thing, let's take away the law that it's not confidential. Let's go from a common sense approach. I have no legal obligation to reduce my bill. I have no obligation to accept as full and final what you're offering. So if you want me to consider reducing by a dime, you'll give me all the information I want. And I guarantee you, if you ask your client, my patient, that if they'd be happy with me looking to contribute, they'll give you all the authority you need to give me all the information I need to make that decision to help them when I'm not required to.
Okay, our next question. If the patient and attorney sign the lien for treatments, however, cupping therapy and massage therapy are not part of our normal treatments we bill, but the patient likes to do cupping and massage, could they pay out of pocket for those services and we provide invoice for services rendered so they can take it back to their attorney to get compensated? I am located in California, if that helps.
Well, first of all, right now with the NSA, you're going to need to reveal on even a personal injury patient, what that treatment is. And when it's outside, And you got to be careful. If you're going to charge them separately on, say, massage and whatnot, are you using cash rates? And are those cash rates much below your normal rates? And if that's treatment during the same time as the personal injury, boy, that's going to create some complexity and to challenge your bill by a savvy defense attorney. For the patient's sake, for the PI attorney's sake, I would not be giving them at your facility those other kinds of treatments during the pendency of that treatment. If they go someplace else and do whatever, you have no control over that. But I wouldn't do it as part of the case unless it was part. By the way, massage can be a legitimate part of treatment for PI too. So I don't want you to think that it can't be part of it. It depends upon your treatment protocol and what's right. I do have an issue with passive treatments. Be careful of the hot packs that go for more than like a week, because you can get those at the CVS. So you want active therapy, and you're using trauma diagnosis codes and active therapy. Those are some real keys. So if it fits within that, use it. If it doesn't, be careful.
Okay. We've had a few attorneys that would like to make modifications to our lien. What are your thoughts on this?
By the way, most of them don't even read it. I've had clients of mine literally told me they've used it over 1,000 times, and they can count on one hand how many times it's been, even a word's been changed. So most of the time they don't change it. When they do, well, first of all, I think, okay, it's good. That means someone reads it. I actually give a little more kudos to those that actually read things. So I like that. Look at what they're changing. It might not be a big deal for you. If it's interest, I think you need that and you want for extra protection. What you don't want them change is fiduciary duty. You got to be careful of what they're trying to change. And in the end, the patient signed it first. The patient didn't change probably anything. So in the end, you could say, no, I'm not agreeing to those changes. The patient signed without those changes. Make sure you keep that one without the patient's signature. And unlike the lien at PI Made Easy, we actually say, and there's a provision in there, if the provider is not initialed next to any change, the original language takes effect. Isn't that great? When they try to change it and you didn't initial it, your staff mistakenly just filed it, it doesn't apply. At least you have a legal leg to stand on. So get into dialogue with them, let them realize you're the one that has to wait all this time to be paid. And if you're going to get protected property like a regular business owner would, why should you take that risk? Talk to them. Pick up the phone and call. If it's a staffer doing it, talk to the attorney.
Well, thank you so much. I am so
you.
appreciative of you being here. And if y'all have additional questions, I really encourage you to email Michael and his team. If you're like me, you always think of questions after the webinar. They just come to me at the most random times, not while we're doing it. It's just the craziest thing. So make sure you reach out to Michael and his team. They're so wonderful and fabulous, and they're so great. And they'll reply to your questions and get right back to you. I'm so sorry, guys. We're running out of time. Just wanted to remind you that next week we have Don Rasmussen. He's going to be here to talk about 2022 Biden tax law changes and how they can affect your personal income. And then we're going to have Aaron Reynolds talking about the future of our workforce. I don't know if any of you guys have had to hire anybody lately, but there are more jobs available than there are people to fill them. So that's it's really difficult. And he's just going to talk about some things about what we should be looking for. So in February, we're going to have a great webinar with Abigail from NCMIC about what is the best kinds of business insurances. Are you properly insured? We don't want you to be overinsured, but we don't want you to be underinsured to protect your practice, because you got to protect your assets. So then we're also going to be talking about planning patient events, because it is patient appreciation time in the month of February. Shocker, because it's Valentine's Day. It's when we show all the love. And I don't really know anybody other than Dr. Hillary Hushauer, who's been when y'all get a load of her and what she does in her community to show the love to patients, your minds are going to be blown. Her level of creativity. And literally, she's just part of her community's local events calendar online, because she throws these just wonderful events to show the love. So we're going to be talking about that. So I hope you all have an amazing day, a fabulous week, and I will see you here same time, same place next week. Bye, y'all.